May I please, Your Lordship?
Yeah.
My Lord, I beg to mention item number 7 to 10, my Lord. It's an income tax appeal, my Lord. The consent of the other side, my Lord. May I pray, my Lord, matter may be adjourned today, my Lord. And let it
Right.
be. Lordship, in this matter, my Lord, several hundred crores of rupees involved, and we require the instructions from the department, my Lord. The concerned officer is not available, my Lord. My Lord, let the matter be come up on any other day, Lordship, after 2 weeks.
Let us have a chance to understand this problem also.
Lordships, otherwise, my Lord, we require departmental assistance in this case.
Yeah, for?
I am for the department, income tax, PCA, Principal Commissioner of Income Tax.
Lordship, I am for the respondent, Lordship.
Yeah, Mr.
I'm S. Chetty, Lordship.
Huh?
I'm S. Chetty, a senior standing counsel.
Okay. Huh? Okay, Mr. S. Shetty, Senior Standing Counsel
Lordship.
of Income Tax. Praise for agenda.
Lordship, I am for the respondent. Let it be on
Mrs. Roy appearing for
the respondent.
the respondent does not have any objection to this.
Lordship, let it be on 16th or 23rd, Lordship, because the outside councils are coming, Lordship.
Okay, when do you want?
16th of September or
This is the matter on 16th.
Lordship.
Deeply obliged, my Lord.
May I please, my lord?
Yes.
I beg indulgence of your lordship, my lord, for listing a matter, my lord. This was fixed on 23rd of, my lord, July, but it has not been listed. Matrimonial appeal, my lord.
When do you want?
On 22nd, my lord.
22nd?
22nd, Friday,
No, not Friday.
my lord.
Thursday or
26th.
Wednesday? Huh?
26.
27?
My,
I have also a similar prayer, my lord, for listing, my lord.
27.
27. Yes, obligement.
May I please, Your Lord, so I beg to mention to criminal appeal from jail, my lord, to come up for admission on Friday, my lord.
Not Friday.
My lord, that is fixed, my lord.
Because I've got to write earlier.
My lord. The urgent, my lord, it is criminal appeal.
Madam, you have got to follow me to Aizol if you want to come.
My lord, 27th or next.
27th.
Must be.
may I please, Your Lordship? I'd like to mention-
There is a problem on
May I please, Your Lordship? I'd like to mention item number 3, my lord.
item 3. Yes.
Assisting counsel, Mr. P.K. Das, he is not out of station, my lord. Can this matter be taken up to 2 weeks, my lord?
Who is for? Right. On the prayer for adjournment made on behalf of Mr. P.K. Das.
P.K. Das.
Then counsel for the appellant in criminal appeal 146 of 2018. List the matter after 2 weeks.
Deeply obliged.
May I please, Lordship? Lordship, I beg to mention item number 2, Lordship.
Yes.
Lordship, matter may be kindly taken up after 4 weeks, Lordship. Lordship, the talk of settlement is going on.
I know. Okay, that the next date is 22nd date.
Lordship,
Right. As settlement talks are still not over. List the matter after
the 4 weeks, Lordship. 4 weeks, Lordship.
4 weeks. Fine. After 2 weeks. You 22nd, you'll finalize everything. 22nd is the next day. 2 weeks.
Please, Your Lordship, I beg to mention item number 5 of today's list.
Yes.
As there's mediation process going on,
Mediation is still going on.
Yes.
Right.
22nd is the next date.
Okay, as mediation talk that's going on, this is the matter after 2 weeks.
But please, Lord, I'm praying for listing of an IA criminal, my lord, this Friday, my lord.
Your date may be fixed.
Hey, give a date on this item 5.
Listing of one IA criminal, my lord, this Friday,
Or what?
for orders, my lord, newly freshly filed.
Regarding what? Is it 4:30?
No, IA is for, my lord, transmitting the trial court records back to the trial court so that order of sentence can be passed upon me.
Oh.
My lord, I was absconding during the trial, my lord. so-
Thursday.
Thursday, my lord.
May I please, Your Lordship? I beg to mention item number 6, Your Lordship.
Yes.
Your Lordship, my senior counsel has some personal difficulty due to which he will not be able to do the matter today.
Who is the senior counsel?
Senior counsel, BD Kaur, sir, Your Lordship. He's
What is the problem?
Which one? Six, item number six of eleven. You should inform the other side before mentioning. I'm really, my apologies, Your Lordship. Actually, my senior just arrived last, midnight, Your Lordship.
Same here. I also arrived midnight.
Any short date may be given or.
There's no excuse. What is the matter about?
It's a criminal appeal, Your Lordship. It's a 302.
Any eyewitness?
There are lots. 1, 2, 3, 4, 5.
That's why.
Any short date may be given.
After tomorrow. This is the matter on the prayer made on behalf of Mr.
Your Lordship.
This is the matter they have to. You wanted a short date?
Your Lordship, my senior won't be available on 21st, Your Lordship. 28th, Your Lordship. He is going to Manipur in Your Lordship.
There is the matter on 28.
Okay, Your Lordship.
58. Wait. 58. The 20.
Yes, Your Lordship.
Please, Your Lordship. Lordship, kindly peruse the last order, Lordship, dated 14/5/2025.
Yes.
Lordship, I have just a conflict with the IO Lordship. He told me to send a fresh copy again, Lordship. Earlier Lordship, Justice S. Jahan was have taken the step.
So yes, you're taking the fresh soft copy.
No, I will send the order. It will be suffice.
Which order? This one,
Last order. Lord.
Miss A. Additional people, praise for time. To enable the officer in charge of the concerned police station to issue notice to the respondent number two. Accordingly, how much time?
2 weeks. Lord.
6 time is granted. This is the matter of.
Lordship, may fix the date, Lordship,
Give a date.
after 2 weeks.
Okay.
Lordship, in the meantime, Lordship, paper book may be registered to direct the paper book.
In the meantime, registry to prepare the paper.
Lordship,
Objection already filed. Lord.
objection filed. Deeply applied.
Lordship, the conducting counsel is out of station. I'm seeking for an adjournment for today, Lordship.
Whether he's available or not. And the last occasion, this honorable court has directed me to records the orders of the act, and accordingly I want to place before this honorable court. I may be allowed to call my senior, Your Honor. Details.
What is this matter about?
It is a lordship, it is a compensation regarding the railway.
The compensation under which act?
It is under the Land Acquisition Act, Your Honor.
1894.
1894, Your Honor. Now it is conversion from meter gauge to broad gauge. The some amount has already been paid by the NFLWA. Thereafter, again, they claim that some of the amount have not been paid.
Okay, you call your senior.
Lord.
Yes, anything?
No, Lordship.
I may be allowed to.
So the only thing is basically with regard to compensation.
Yes, Lordship.
What is the difficulty? There's an award with
Yes,
under
yes.
section 11.
Yes. Or what have been passed by the lower court?
To be pronounced, no section 18 reference.
It is at that time the district judge, DC has done the judgment.
Actually, this is the collector.
Collector.
Has to do it. Now, once the collector has passed the award, if you are unhappy with the award, then you'll have to file an application under section 18 for reference. If that is not done, then that means you have accepted the award. So why have you come to the court?
Lordship, in that 11 point of time, there is no judicial forum in the district of Dima Hausa.
How does it matter?
The Lordship,
They
they
must be following the administration of justice rule.
let me call my senior.
May I, Lordship? Lordship, on the last occasion, Lordship, the court directs the registry to make a paper book, Lordship. But Lordship, registry has given a office note, Lordship.
Issue is not the issue. I want to know what the issue is. We want to know What is the issue? It's not the issue about making a paper book. It's, you see, why do you need a paper book?
Lordship, for hearing lordship, the TCR is
What?
required lordship.
What is the issue? What is the matter in issue? What is the matter to be decided?
Lordship, kindly lordship, my senior has to come lordship.
Tell your senior, don't try to explain what you don't know.
But lordship, in the TCR lordship, the title suit filed in 2007 in Dimahasa lordship, that is missing lordship. So a office note is given.
There is a title suit. This is what? This is a appeal.
Heel appeal.
Or is that-
Appeal,
huh?
lordship.
Heel
Lordship,
appeal.
first of all, lordship, the appellant filed a writ petition lordship, and that was subsequently converted to RFA. Then lordship on 2024, it is converted to heel appeal lordship.
Maybe we'll find out what the issue is. It's basically a issue of law. You see, the thing is that unless it's a disputed question on the area of the land acquired, if that is the issue, that's a different ballgame.
Lordship, at that time in Dimahasa lordship, the DC lordship, he acted as a civil court lordship. There is a act.
So
Lordship.
how does it matter, madam?
But
You
lordship,
see, I'll tell you,
yes, lord.
in Nagaland, in Mizoram, everywhere, there used to be the administration of justice rules.
Yes, lordship.
Okay. There was 1947, 1953, there's so many justice rules.
Yes.
How does it matter? They've been given some judicial powers. Not exactly, you cannot call them judicial officers, but they were civilian officers doing dispensing justice under those rules. So how does it matter? How does it touch upon the issue? What is the issue?
Lordship, the compensation is determined by the DC at that time, lordship.
Madam, under the 1894 Act, compensation has to be decided by the collector. That is the DC. Then what is wrong?
The judgment is challenged by them, lordship.
What judgment?
That-
You are not understanding a thing. 1894 Act is not a judgment.
Yes.
It is an act.
Yes.
I may be allowed to use.
I don't know what you're trying to say. You're for the state.
No, lordship, I am for the respondents, lordship.
Respondents are the landowners.
Yes, lordship, they are the landowners.
Okay. So you have been given compensation.
Yes, lordship.
Under what? Under some award.
Yes, lordship.
Award made under which section?
Lordship, that I don't know, lordship.
You don't know. That's what. Please read. And then you're trying to say something.
Yes, sir.
So please understand what you're trying to say. When you make award is given under section 11, pronounced under section 12 probably. And if that award is not acceptable to either you or to the paying authority, then they have to go under section 18. Did you go under section 18? No.
No.
Who filed the suit in the lower court? No idea.
Their file.
Huh?
Their file.
They have filed. Claiming what? You have challenged the award or what? No idea. Huh? Yes or no? All your seniors.
Yes,
And
lordship.
present, we are here. What are we doing here?
Lots.
Where are they?
I just may be allowed to follow.
Call them. We're waiting. Accepting the judgment. How's judgment? What is happening? This cannot be the order and the challenge. If it's a field, it's the fishing order.
The RFA in 137. Yeah. And 12, 14, 28, 6 of 2005.
Let's read this. With reference.
In this case, the paperwork has to be constituted.
You see, before a paper book is to be prepared. What is the issue here? Now, first of all, I find that there are some PIL orders. There is some, now, this matter pertains to, as what I have gathered, that we have gathered, the LA Act of 1894, correct? Is it? Is it? No.
Hmm.
That's what they were saying?
Both sides.
It pertains to what act?
Well, it was no act. Well, what happened? What happened? NFL undertook a project.
Huh?
NFL Railway undertook a project to broaden the meter, to convert the meter gauge to broad gauge from Badarpur, from Lamning to Badarpur. The land was duly acquired
Under what law?
under the Land Acquisition Act.
That's what I'm saying.
No.
The land
Let me finish.
Ah.
So far, those acquisition is concerned, all payments were made. These
Land Acquisition Act of 1894.
all were paid.
Which act? Which act? There are different acts. Which act was applied for paying acquisition?
No, that is not the case here.
I know,
Oh, yes.
but I want to know for my knowledge.
1894.
1894.
Hmm.
So 1894 was
Then payment were made.
payment.
Now some other persons, after making of this payment, some other persons has instituted a civil suit.
Okay.
Their contention is that due to broadening the meter gauge line to broad gauge line, their land was damaged.
Damaged.
And for that,
Not acquired.
not acquired. So they want some compensation.
So that is a damage suit.
Damage suit, yes, that is a damage suit. Exactly so, Milan. Now they filed a suit, and this suit was decreed initially. Thereafter, the decree passed by the learned civil judge, learned district deputy commissioner was set aside because the land it is within the territory of 6th scheduled area.
How does it matter? 6 scheduled areas can also be allotted.
No problem. So that was vacated. Thereafter, my lord, the agreed person went to the scheduled caste commission, a scheduled tribe commission.
No. Let us be very clear. The suit filed before the court of the deputy commissioner.
Deputy commission.
Under what law?
For damage suit.
Under what law?
Damage suit can be constituted by the civil law, by any civil suit.
You see, now there are many aspects. You see, prior to, unless the judiciary was separated in that area, it's either done under the administration of justice rules. I do not know if it's followed here in Assam, in the district council area, or under the district council courts act. I don't know. So because they are saying that there was no judicial officers in that Dimasao area, correct? Was there any judicial officers?
No, at that point of no judicial.
No judicial officers. So the civil officers were dispensing justice.
Yes.
Civil officers were dispensing justice. Civil officers will dispense justice under some law. It has to be under some law. They cannot operate in a vacuum. Okay, they cannot operate in a vacuum. Now, which is the law under which they were dispensing justice. It has to be there. So you see out here it says the Assam Autonomous District
Because of
Administration
1954.
of Justice Act
1954.
1960.
Hmm.
Is it? Then North Kachar Hills Autonomous District Administration of Justice Rules 1955.
Hmm.
Is it? So under this, they're dispensing justice.
Yes.
Now,
Now, my lord, initially, my lord, suit was decreed
by whom? By which court? By
by
the
the
DC.
Deputy Commissioner Court, my lord.
By the DC. Then now,
Then, my lord,
who set it
immediate-
aside? Who set that decree aside?
he himself, after a few days.
You.
Not if in his own way, he has set aside the decree. Then, my lord, they approached before the Scheduled Tribe Commission. Then Scheduled Tribe Commission also dismissed their petition. Then, my lord, they approached before this honorable court by filing a PIL. Now, this PIL court passed an order, all right, fresh proceeding may be initiated, considering whether there is inventory rights, etc., etc. Then, my lord, an order was passed
By whom?
by the Deputy Commissioner. That order was assigned by the Railway Authority.
What was the order passed?
Well, I have prepared a note. May I give it to you, Lordship?
You read from your note.
Okay.
Why? You read, I read, same thing. So what does the note say? What does the deputy commissioner say?
No, my lord, notes. Villagers approached before the National Commission for the Scheduled Tribes for due relief to the Scheduled Tribes. The National Commissioner called for the report from the concerned Deputy Commissioner. The Deputy Commissioner prepared a report on 6/5/2006. The report so prepared was submitted to the Scheduled Tribe Commission in terms of their direction. This report was addressed to the Research Officer, National Commission for Scheduled Tribes. In this report, it was specifically stated that the Railway Authority had made payment of rupees 19,15,040, 19 crores, 59 lakhs 47,257 to amongst 1,110 numbers of families whose lands were acquired. After that payment, villagers of defined villages approached for the payment of compensation for their land. It was stated in this report that the person who had prepared title, who has proper title over the land, had availed the land compensation and deduct value. The villagers who instituted the civil suit are the encroachers of the railway land, and they were not entitled to compensation. That was the finding of the Scheduled Tribe Commission. Thereafter, they approached before this court by filing a writ PIL. So the villagers who could not get their relief from the Deputy Commissioner and the National Commission for Scheduled Tribes formed a coordination committee called as Affected People Coordination Committee, espoused their causes in defined forums, including courts. This coordination committee instituted a public interest litigation numbered as PIL number 61/2007. In this Honorable Guwahati High Court, it was their case that the affected persons were residing over the plots of land in question by constructing dwelling houses. They had planted valuable trees. The land under their possessions were utilized for agricultural occupation. Their case before this Honorable Court was that they have acquired prescriptive rights over the land, and they cannot be evicted without paying compensation, which was denied by the railway authorities. That was the case before the division bench. PIL was disposed of on 27/6/2008. with a direction to the Deputy Commissioner NC Hills to make inquiry, fresh inquiry, to whether the land from which the villagers were evicted belonged to the railway or to the concerned tribal villager who claimed to be in possession, and how long they possess it. If the Deputy Commissioner finds that the concerned villagers acquired prescriptive rights over the land and plots, shall pass necessary order for payment of adequate compensation by the railway authority. Folder 2. Acha. Pursuant to the direction of this Honorable High Court, an inquiry was carried out by the Additional Deputy Commissioner, who submitted his report to the Deputy Commissioner North Tachar Hills, suggesting for earlier payment of reasonable compensation amounting to 39 crore 77 lakhs 50,363 on the basis of assessment by the Revenue Authority. The Deputy Commissioner NC Hill issued letter directing the Deputy Chief Engineer Construction NFLA Learning to take necessary action for making early payment for compensation. The Railway Authority, now against that order, the Railway Authority preferred a read petition numbered as such and such. This Honorable Court filed this judgment and order dated 3/5/2011 held that the inquiry report and subsequent letter of the Deputy Commissioner NC Hills are not sustainable. Again, that was set aside in the eye of law, and consequently they were set aside. However, this Honorable Court held that the order would not be stand on the way of the Deputy Commissioner to carry out fresh inquiry in terms of the direction passed by the PIL number 61 against 27. Again, fresh inquiry was held. The aforesaid order dated 2003 to 5/2011 was put to the challenge in the writ appeal, numbered as writ appeal number 182/2011. By stating inter alia that the Railway Authority had failed to furnish the evidence of ownership over the land. The writ appeal was disposed of, directing to conduct fresh inquiry by the Deputy Commissioner.
These are all in the PIL. no?
PIL.
The PIL.
Then thereafter the
Where's
Deputy.
the writ appeal? Where's the question of writ appeal? I'm not understanding. When the orders are passed in the PIL.
No, initially order was passed on PIL.
Where's the question of writ appeal?
No, initially order was passed in PIL
By a single bench.
by the division bench. Pursuant to the order of the PIL, Millard, the Deputy Commissioner conducted an inquiry and submitted his report. This report was assailed in a writ petition. The learned single judge set aside this order, and against that order, a writ appeal was prepared. And the writ appellate court held that the fresh inquiry is to be conducted.
Then what has happened now?
Thereafter, Millard, pursuant to the direction of Honorable High Court, inquiry was carried out by the Additional Deputy Commissioner, who submitted his report to the Deputy Commissioner NC Hills, suggesting for early payment of reasonable compensation amounting to such and such. The Railway Authority preferred writ petition numbered as writ petition numbered as such and such. This Honorable Court, by its judgment and order dated 3/5/2011, held that the inquiry report and the subsequent letter of the Deputy Commissioner NC Hills are not sustainable in the eye of law, and consequently they were set aside. However, the Honorable Court held that the order would not stand in the way of the Deputy Commissioner to carry out the fresh inquiry in terms of the direction passed by the PIL number 61 of 2007. Now, the aforesaid order dated 3/5/2005 was put to challenge in the writ appeal number WS such and such. The writ appeal was disposed of on 29/2011, directing to conduct fresh inquiry by the Deputy Commissioner. Now, against that order, the Deputy Commissioner conducted an inquiry. Now, that inquiry report is being assailed before this Honorable Court. In terms of the order dated 29/9/2011, the Deputy Commissioner Dimahaso Haflong initiated an inquiry. But
This is a question of fact. You are challenging the deputy commissioner's report which has been made on the basis of a division bench order. Correct?
Hmm.
This is a question of
That
fact,
is a civil suit.
whatever it is.
is
Rightly or
civil-
wrongly, the order has been passed by the division bench.
Division, deputy commissioner.
No, on the basis of a division bench order,
Ah.
on the basis of a division bench order, the deputy commissioner has made a report on the factual aspects of the case. Correct?
No.
No.
Deputy commissioner entertained a civil suit.
Correct.
Civil suit,
No, Mr. Counsel, the order that is being put to challenge today,
against an order of the civil suit. Not the inquiry report, the civil suit. Not the,
Mr. Dasgupta, the appeal, this is an appeal,
against the civil order of the civil suit.
this is a first appeal.
Yes,
And this is against the order passed by the civil court.
yes.
where is the civil court order?
You folder to the judge.
Take it off.
Where is the order?
May give the.
No, where is the appeal petition? The order under challenge, where is it? Is it here?
In the appeal memo, please point out the page.
Yeah, it took it. I have prepared some 3 folders where the relevant.
No,
Well-
we just want one order. The order under challenge shows that.
Oh, yes.
The way it has been actually down. This would be. Whereby all the others not balancing. Both reasonable. They can be balancing. It doesn't.
None of opinion. No.
6 of.
It will be, I think.
Problem. Yes,
Page 22, Milord. Title suit number 6 of 2005.
okay. So out here, you see out here, you have put to challenge. Let us see.
Initially, we filed a civil suit, Milord. Initially, we filed a first appeal. Then it was pointed out by this court that
No, in this page 22, what have you put to challenge?
the decree of the civil court, Milord,
Where is the decree of the civil court? Let us see which page is it. What is the decree? What is the decree date? This is title suit.
yes, page 35. Last portion. The claim application of title suit allowed and the railway respondent, NF Railway through GM, is directed to make payment of such and such amount amount to the affected person within a period of 30 days from the date of this order, failing which the railway respondent will have to bear together with the interest of 6% per annum from the date of filing of the case till the date of the order at the rate of 9% per annum from the date of this order till the date of the actual payment. Against that, my lord, we preferred a fast appeal,
This present case.
the present case. Now, my lord, what happened?
On what ground are you challenging this order?
No, again, my lord, first appellate court, you can agitate all these things.
Agreed, but on what ground do you say that this order is bad? On what ground is it bad?
Grounds, Mr. Dasgupta, grounds of challenge.
Oh, it's grounds of challenge. Actually, my lord, today was date fixed for the filing of paper book. In that,
Paper book is not the issue. More than the paper book, whether the manner in which this entire case has been taken up has to be gone in. Not of issues. Anyway, right. What does the order say? Last order. You see, this paper book is going to be thick, very thick. How are they going to make?
though all these papers are not very relevant. The
Then-
learned division bench indicated what the papers will be relevant. Claim evidence, documents, and claims. Plaint as written.
Right. As the paper book has not been prepared, this is the matter after 4 weeks. The issue is nothing big. The issue is gone. Question of fact, how can we go into much?
The so far first appeal concerns no substantial question of fact. First appeal is to be considered on the basis of the evidence as well as the merit written statement.
Oh, but first appeal is a continuation of the suit. Everything can be gone in. And you take it. What's this one? For example. Next time, I think you should prepare yourself a little more. And you
Well, I have prepared my written argument also I have prepared. Issue was prepared, I have prepared.
You could not tell us the grounds for challenge to the order under challenge.
No, not only one ground, there's defined grounds for it.
In the grounds, okay, tell us what is the ground.
Lordship, senior is out of session, Lordship. Thank
What is the grounds for challenge? You said that we know the grounds. What is the ground?
No, in terms of the order dated 29, the deputy, actually, Millard, I am not prepared today, Millard, because of the fact it is case fixed for the preparation of the pair book. That was, though I have prepared my written argument since long back, about 2 years back.
That's what we are saying. You are not prepared today.
Yes, sir. But I have prepared my written argument. That is fine.
But you could not read it out to us. What are the grounds of challenge?
Should I read it again?
Only now we have passed the order. Then you'll be more prepared. Next.
I think item 11.
Yes.
Lordship, my junior tried to contact. So it means the number belong to somebody else now. Okay. Lordship, what is,
My lord, this is the salary certificate I have given to the person. No, he is getting 13,055
What is he working as?
in the Poddar company, my lord. He's a sales boy.
Just
My lord.
file an affidavit to that effect.
Yeah, I can
Proper.
file. This is the record. I can file the affidavit. No
Lordship,
problem.
may I submit one thing? It has come up on record from the evidence of DW2, who happens to be the mother of the respondent. Lordship, may kindly have a look at flag mark with orange color portion and this third paragraph from the bottom, my lord. in such a insecure atmosphere. Evidence of.
In the judgment.
No, evidence, this orange color flag mark. No,
There's no orange color.
it's there. On the record, record from. Record of it. Evidence of Sebika. Sebika Das. Lordship has found it?
Yes.
Lordship may kindly turn the page and the last portion. Third paragraph from the bottom. In fact, fourth line of the third paragraph. Stay in such an insecure atmosphere. At Tono's residence, Kirby has been staying with her since December 2015. Lordship has found it?
Which paragraph 3, 4, 5?
No, from the bottom, before the oath. 6, it's a 5. 5, fourth line.
Tanna's parents became angry.
She had being unable to maintain herself and stay in such an insecure atmosphere at Tono's residence. Kirby has been staying with her since December 2015. On 10th March, when Kirby went to stay at her matrimonial house, she saw an extra lock on her door. Tono's parents pushed her out their campus and said that they would not allow her to enter inside their campus. So in the address, Lordship, she has mentioned she's a resident of, my lord, Ward Street, Ujan Bajar, house number 13, Guwahati 1, PS, Lotakil. So for end of justice, may I pray, Lordship, through Lotakil police station, notice may be served and last and endeavor may be made, my lord. This is a matrimonial dispute.
My lord, your lordship will take the cross of the subject.
By recording the fact that the learned PT had declined to produce further evidence. Also, the learned defense counsel had also submitted that there was no necessity to adduce further evidence from the side of the accused person. With regard to the last seen theory, as required under section 7 and the section 106 of the evidence.
As my lord,
Huh?
since no further witnesses has been produced.
Correct. That's already there. Next. The para 7 of the impugned. No, next para. The next para, the learned trial court further held the trial court thereafter considered thereafter came to a finding that the appellant Abdul Aziz and Jasmat Ali did not advance any explanation with regard to the last seen together theory and held that the said last seen together theory was applicable to the facts of this case. To the fact of this. Without any additional evidence being recorded by the learned trial. Next part. The learned senior counsel for the appellant submit that when this court has remanded the case back to the learned trial court for taking additional slash fresh evidence, so that the learned trial court could come to a proper finding as to whether the evidence, as to whether the additional slash fresh evidence could determine whether the appellants were guilty or not guilty of the charge under section 147/302 IPC. The learned trial court could not have come to a different finding in the second round of consideration, when when the evidence that it considered was exactly similar as during the time of consideration in the first round. He also submits that the learned trial court could not have reviewed its own decision, passed by the earlier judgment dated 28/9/2015, in the absence of any additional tax evidence in terms of section 361 CRP.
362.
362 CRP. That's all. Next. That's all. I'll list the matter tomorrow. At part time.
Well,
You put down, take down para 73, huh? Take down, you just say para 7 and 73. No, para 7 and 50 of the impugned judgment, the latest one, impugned judgment is reproduced here and below as follows.
Maybe the thing. My lord, here one brother filed appeal, my lord, and victim disease is,
Huh?
my lord, the victim disease is the my lord, brother of present appellant.
Disease victim is
Brother of present appellant.
brother.
Yes, sir.
So it's a brother killing brother.
Well, actually, my lord, this is a accidental death, my lord.
Okay.
And it is
Where accident caused by the apparent.
no, my lord. He, my lord, fall on the my lord, on the my lord pillar, newly my lord under construction pillar, and there is a my lord 4-5 rods,
rod.
my lord, and right hand side, my lord, it was my lord entered, my lord.
Let us see.
Lordship, kindly, I may be allowed to just first show my lord evidence of IO, my lord. Short evidence, my lord.
Okay.
It is, my lord, in the paper book, page 21, my lord.
Yes.
Here, my lord, he stated that on 18/7/2023, I was posted at Udarbon PS as officer in charge. On that day at around 6:30 AM, I received information from one person of the said locality informing that last night a dispute took place between two brothers in which one brother was killed and he was brought to the Udarbon Branch Primary Health Center, PHC. From there, in spite of, it should be like, instead of taking the dead body to SMCH, Silchar Medical College and Hospital. It was taken back to the house and attempted to bury the dead body secretly. On receipt of the same information, I made GD and GD by number so and so. It is also important, my lord, dated so and so, and immediately proceeded to the place of occurrence. I recovered the dead body first and then prepared the sketch map of the place of occurrence. Thereafter, inquest of the dead body was done in presence of magistrate and it was sent to the SMCH for post-mortem examination. The inquest was conducted by the circle officer Sri so and so Bordoloi. I recorded the statement of the witness. I seized the bloodstained Genji worn by the deceased. Yes, by the person. The weapon could not be recovered. The wife of the deceased was in the police station. Now, my lord, she is police station and she lodged the FIR. I recorded the statement of the complainant and thereafter apprehended the accused Runu Begum Lashkar. My lord, Runu Begum is the, my lord, one of the, my lord, sister of the appellant before your lordship. She was acquitted, my lord. I interrogated the accused person and forwarded her to the court. On 19/7/2023, at night, I apprehended the other accused, namely present appellant, my lord, that is Mashukuddin Lashkar, and forwarded him to the court on the next day. I collected the post-mortem examination report and on the completion of the investigation submitted charge sheet against the accused person Mashukuddin Lashkar and Runu Begum Lashkar under section so and so exhibit so and so is the certified extract copy of the GD number so and exhibit so and so is my signature as officer in charge of Udarbon PS. Exhibit so and so is the inquest report and exhibit so and so is the signature of circle officer Sri Rituraj Bordoloi, which he put it in my presence. Exhibit so and so is my signature after registration of the case. Exhibit so and so is my signature in the seizure list. Exhibit so and so is the sketch map, and exhibit so and so is my signature. Exhibit so and so is the chart sheet, and exhibit so and so is my signature. Cross, my lord, it is important. On 18/7/2023 at about 6:30 AM, informer came hurriedly and informed me about the matter and left. So I could not record his name and address. I did not examine that person as witness because I could not trace him out. I went to the place of occurrence along with battalion and 1 UBC. Near the dead body, I found the family members only. I did not examine all the family members as witness in the case. Now, my lord, this is according to my lord very important. PW1, my lord, Rumana Begum Lashkar, who is my lord, wife of the deceased, did not state before me that his brother-in-law, my lord, sorry, it is my lord, sister-in-law, brother-in-law deceased came there and obstructed him for doing the work. PW1 did not state before me that my younger brother, namely Zilan Ahmed Lashkar, tried to take my husband to hospital, but accused, namely Runu Begum Lashkar, obstructed him. However, my younger brother hired one auto rickshaw and I, along with Runu Begum, took my husband to Udarbon Hospital, from where he was referred to SMCH, but my sister-in-law Runu Begum did not allow me to take my husband to SMCH, saying that my husband had already expired. I then wanted to go to Udarbon PS for filing a case which was also obstructed by the said accused. After taking my husband to our house, accused Runu Begum wanted to cremate him, which I did not allow. Now, my lord, last part, I went to, my lord, this is maybe important, my lord. I went to Udarbon Branch Primary Health Center, but doctor expressed his ignorance regarding this case. PW6 Raina Begum Loskot did not state. Raina Begum is the, my lord, a mother-in-law of the deceased, my lord, did not state before me that Runu Begum told her. Runu Begum is the, my lord, another co-accused. She was acquitted, and my lord, he is the, my lord,
Raina Begum. Begum means woman, no, basically.
yeah, Begum always in the woman.
Yeah, you're using he and he as you want.
Some typographical mistake.
Runu Begum told her that Asik disease, my lord, suffered a stroke and he died. My lord, here from my lord, it is my lord, if you state where my lord perceive this evidence, my lord, here my lord, the man was my lord in the accidental, my lord, incident, he was my lord died, my lord. Even my lord in the home treatment, he could not be saved, my lord, he died, my lord. And there are my lord, normally as
Nothing is clear from here. What do
my
you
lord,
mean?
because my lord here my lord, where my lord main hospital, it was claimed that my lord he was brought there. And where from my lord, instead of my lord his postmortem in the Silchar Medical College, he was my lord brought to his own house, my lord, where he was my lord trying to be buried, my lord. And police found my lord secret information from the informer that there was an incident and they are my lord secretly going to my lord bury this dead body. So you come and take action according to police, my lord. And police came, my lord, Somoto, and took the dead body to the SMCH, my lord, where my lord postmortem examination was done. my
Let
lord.
us see the FIR.
FIR, my lord. Now, my lord, FIR at page, my lord, it is at page, my lord, 4, my lord.
Yeah.
Lordship, here, my lord, kindly have a notice, my lord. In the FIR, my lord, this GDNT is different, my lord. GDNT, my lord, page 1, it is GDNT according to this FIR is 3, my lord. My lord, it is page 1, my lord, under, my lord, clause 3, general diary reference, entry number 003, my lord. But, my lord, IO referred, my lord, different GDNT. Under which this, my lord, prosecution case was, my lord, conducted. It is GDNT number 383, my lord, dated 18/7/2023, my lord.
Where do you get this 383?
Yes, my lord.
From where?
My lord, it is IOS evidence page 21, my lord. In the first paragraph, my lord, he stated that, my lord, after having, my lord, this secret information from an informer, which was admittedly not examined in this case also, my lord, and by recording this GD entry number, my lord, 383, he went and investigated the matter, my lord. But here in the main affair, it was, my lord, GD entry is different, my lord. Now, my lord, FIR part is, my lord, at page 4, my lord. Kindly, my lord, I am reading, my lord. Sir, when my husband Ashikuddin Loskar, as Ashikuddin reached whom after buying bricks, sand and cement from Udarbon market and was entering whom at that very moment the aforesaid disease accused Mashukuddin called my husband outside of whom to the courtyard, and first he hit him in the scrotum and made him fall to the ground, and when he was about to assault with a sharp dagger from his waist, I and my younger brother Jilon forbid him, and we were kicked and pushed and were made to fall to the ground, and in front of us he stabbed my husband twice in his chest, and in twice, my lord, it is important, twice in his chest, and fled from the house. When I took him to Udarbon Health Center, the accused Runu Begum hid the truth and lied to the doctor that it was a case of accident. Then the doctor referred the victim to Silchar Medical. When the incident occurred, it was around 8:30 p.m. and my husband died at the place of occurrence. Total contradiction, my lord. And he was not taken to Silchar Medical. I therefore pray to you to investigate and take necessary measures against the accused to in connection with my husband's murder. The incident took place on 17/7/2023 at 8:30 p.m. In the FIR itself, my lord, in the short FIR, my lord, there is a serious contradiction, my lord. It was stated that, my lord, he was died already, and according to previous
What is the date of this FIR?
FIR date, my lord, 18/7/2023, just below left hand side, my lord. Now, lordship, her evidence, short evidence, page 9, my lord.
Let us go to page 6. What is this? Page 6. Charge.
Yes, my lord, it is, my lord,
Charge framed under what?
committal order, my lord.
No, charge framed under
Yes, my lord, it is, my lord, charge order.
120B.
Yes. 202. Firstly, second,
234.
34. 34 is not there.
And under 20134.
Yes, my lord.
3 charges.
Yes, my lord.
Yes.
Now, my lord, her, my lord, evidence, page 9, my lord.
Yes. Who
It
is
is
this evidence?
evidence 1, my lord, informant, wife of the, my lord, deceased, my lord. Page 9, my lord, my husband collected sand, cement, etc. for construction of staircase with ramp for taking his motorcycle inside the room to save the motorcycle from rain and sunlight. My brother-in-law accused came there and obstructed him from doing the work which was about to be started. The accused gave my husband a kick in his scrotum, to which my husband fell down. He accused then took one dagger and inserted the same in various parts. Now, my lord, various parts of the body of my husband, and taking the dagger, the accused person fled away from the spot. When we tried to apprehend him, my younger brother, namely Jilon Ahmed Loshkar, tried to take my husband to hospital. My lord, this is important according to me, my lord. But the accused present in the dock, namely Runu Begum Loshkar, obstructed him. However, my younger brother hired one auto rickshaw, and I, along with Runu Begum, took my husband to Udarbon Hospital, from where he was referred to SMCH. But my sister-in-law, Runu Begum, did not allow me to take my husband to SMCH, saying that my husband had already expired. I then wanted to go to Udarbon PS for filing of a case which was also obstructed my said accused. After taking my husband to our house, accused Runu Begum wanted to cremate him, which I did not allow. On the following morning, my father came, and with him I went to Udarbon PS for lodging the case. Police from Udarbon PS came to our house, and after that they took the dead body of my husband to SMCH for post-mortem examination. On the same day, after returning the dead body from SMCH, he was cremated after janaza. Our neighbors advised me to go to my father's house with my 6-month-old baby for our safety and security. Till date, I am residing in my father's house. Police recorded my statement. In cross, my lord, I got married about 1 and 7 months prior to the incident. I used to live with my husband and child separately within the same campus. The accused Masuk Uddin Loskar also used to reside in the same house. My mother-in-law and my 3 sister-in-law also reside. Accused Runu Begum is married, but she reside with my mother-in-law in the same house since before my marriage. There are many houses, but I am not acquainted with them. I have seen 2-3 Hindu ladies came to the spot at the time of incident, but I did not see the other person who came to the spot at the time. At the time of incident, I started shouting, but accused Runu Begum did not allow me to shout. It is not a fact that I did not state before the IO that my brother-in-law accused came there and obstructed him from doing the work which was about to be started. It is not a fact that I have deposed falsely that the accused gave my husband a kick in his scrotum, to which my accused fell down. He accused then took one dagger and inserted the same in the various part of the body of my husband, and taking the dagger, the accused person fled away from the spot where when he tried to apprehend him. It is not a fact that I did not state before the IO that my younger brother, namely Zilon Ahmed Lashkar, tried to take my husband to hospital, but the accused present in the dock, namely Runu Begum Lashkar, obstructed him. However, my younger brother hired one auto rickshaw, and I, along with Renu Begum, took my husband to Udarban Hospital, from where he was referred to SMCH, but my sister-in-law Runu Begum did not allow me to take my husband to SMCH, saying that my husband had already expired. I then wanted to go to Udarban PS for filing of a case which was also obstructed my said accused. After taking my husband to our house, accused Runu Begum wanted to cremate him, which I did not allow. The Ejahar was written as per my instruction. I do not remember the name of the scribe of the Ejahar. It is not a fact that my husband sustained injuries due to falling on the iron rod. There were no iron rods in the site of the construction of the staircase, which was not even started. My house is situated at a distance of about 50 feet from the house of my mother-in-law, which is intercepted by a courtyard. It is not a fact that the accused Masuk did not kill my husband. It is not a fact that I have leveled false allegation against the accused Runu Begum. Now, my lord, independent witness, my lord, brother, my lord, it may be my lord Zilon, who, according to her, he was there, my lord, at the place of occurrence. Informant brother-in-law, my lord. Sorry, brother and brother-in-law of the disease, my lord. This is page 12, my lord. Runu Begum Lashkar PW1 is my elder sister. My brother-in-law deceased took me in his house, and I was staying there for 4-5 days prior to the incident. On the date of incident, the accused Masuk started altercation with my brother-in-law deceased over construction of staircase in my brother-in-law's house. Accused Masuk gave him a kick and he fell down. Hearing the hue and cry, I came out of and saw that the accused Masuk took one dagger and inserted the same in the various part, my lord, of the dead body of the brother-in-law. My sister PW1 and another of her sister-in-law took my brother-in-law to the Udarban hospital. As my brother-in-law expired, he was taken to his house, and on the following day, police came and took his the body for post-mortem examination. I did not go with my sister to hospital as I was guarding the.
Okay, so what do you want to show, which we have read?
Here in this case, my lord, this man, my lord, died, my lord, due to accident, my lord.
Where?
There-
Where's the evidence?
My lord, evidence, my lord. Therefore, my lord, nobody is, my lord, saying same thing, my lord. Only, my lord, here is the, my lord,
Where is your evidence?
my lord, evidence, my lord. We are defense, my lord. We have not given evidence, my lord. But
You could have made yourself a witness also.
yes, my lord. Yes, my lord. Here in this case, my lord, my understanding, my lord, is that basic case that, my lord, which is, my lord, FIR. There is a two, my lord, GD entry, two FIR. And my lord, IO, my lord, admitted that, my lord, he himself came there, my lord.
So,
He got, my lord, and this in.
so he went there, how does it? Why, Ayu cannot go there?
Of course, go there, my lord. But my lord, here, my lord, if my lord information information, my lord, he got, who gave him information, it is not, my lord, here, my lord, this is in a criminal case, my lord, we have to show, my lord, contradiction, my lord, we are benefit of doubt, my lord. One thing, my lord, happened, one thing cannot be described in a, man, three-way, four-way, my lord. If it is correct, my lord, incident happened, my lord, that should be, my lord, stated all the evidence, my lord, in the same way, my lord. And here, my lord, main thing is that, my lord, the main, my lord, instant hospital, my lord. All are saying, my lord, this man was brought initially for, my lord, first aid to a hospital. And this hospital itself is, my lord, denying, my lord, we have not seen.
When were you arrested?
My lord, he was, my lord, from the judgment, my lord.
When did the incident take place?
17.
Huh?
17.
17 March.
Yes, my lord.
17 March 23.
Yes, my lord. And, my lord, one of the co-accused,
Just a minute. Okay. When were you arrested? Date of arrest?
my lord, he is from the, presently, my lord, from the date of judgment, my lord, 1/8/2024, my lord.
1/8/24.
Yes, my lord, from more than 1 year, my lord.
But okay, where did you live prior to that? You were living with your disease.
Yes, my lord.
Same
No,
house.
no, my lord, in the same, my lord, house, my lord, different, my lord, household, my lord.
Same compound, different houses.
My lord, my honest understanding, my lord, is not a, my lord, defense counsel, my lord. It is a pure case of accident, my lord. And they are, my lord.
Accident, then why didn't you find? Why did you
My lord,
disappear?
therefore, my lord, kindly have a look on a serious, my lord,
No, no.
contradiction with the.
Let me ask you one thing. Your brother died on 17/3/23.
Yes.
Where were you?
My lord, he was,
Where were you on that day?
my lord, that is not on the record, my lord. My lord, another aspect is here, my lord, in the, on the record, my lord, before your lordship. One person is saying, my lord, two stabbing. Another person, whole body. And my lord,
So let us see the doctor's report.
yes, my lord, this is important, my lord. Doctor's evidence, my lord.
PM is in 60.
Page 15 is
Doctor
the
is 18 lot. Fine lot.
page.
No, my lord, it is injury part is, my lord, important, my lord. Lordship, kindly have a look this injury part in a one place, my lord, all injury part. Injuries, my lord, page 15, my lord. Rod, my lord. In this, my instruction is that, my lord, this side, my lord, this all roads, my lord, and in a one place.
Whose roads were there? You're building a house.
No, lord, it is there was a, my lord, house was under construction, my lord, and he
Where?
by sleep, my lord, he fall on that rod, my lord. Fall, my lord. Therefore, my lord, all the rod entered in the.
You were there. You were there.
My lord, perhaps, my lord, he was not there, but on the record, my lord, I cannot say, my lord.
No.
My lord, page 18, my lord, doctor's opinion in the cross, my lord. My lord, in one place, my lord, all the injuries are, my lord. Their whole body, my lord, the penetrating injuries may cause by falling upon rod, but not possible by a single fall.
So what happened? So he fell down, then he.
No, lord.
Then he
My
fell
lord,
down.
my lord, in a, my lord, the pole, my lord, there are, my lord, 6-7 rods are there, my lord.
I know.
Yes, my lord. And my lord, it is next, my lord.
Then you see, once you get
This is, my lord, real.
get pierced by the rod.
My lord,
To fall again on the rod, you have to.
my lord, this is
extricate yourself.
exactly this is the, my lord, incident. Exactly.
How do you know?
My lord,
How do you know the exact?
my lord,
Were you there?
my lord, independent witness is there, lordship, kindly believe.
Okay. No, let me see. He says that this is exactly what happened. Let us see how he knows.
My lord,
Let us
here,
see if that witness told you that.
My lord, kindly see page 14, my lord.
Page 14. Yes,
He is independent witness, my lord.
yes, what does it say?
Page 14, my lord, I know the informant of the case. I know the accused person, namely Masukuddin Loskor and Runu Begum Loskor. About 6-7 months earlier, the incident took place. On that day, Sajan Uddin Loskor, the younger brother of Masukuddin Loskor, informed me over phone that my cousin brother died. On hearing, that is, my lord, he is also, my lord, cousin brother of the deceased, my lord. Hearing the information, I came in the house of Ashik Uddin, my lord, this is disease, my lord, and found the dead body of Ashik Uddin was lying on the bed. Sajan Uddin Loskar told me that Ashik Uddin expired on the previous day by falling from the stairs, and some rods were there.
So
in
he
the
was
pillar.
he was told by Sajan Uddin
Yes, my lord.
Laskar. Was Sajan Uddin Laskar a witness?
Sajanuddin Loskar was not witness, my lord.
The-
My lord, their single word allegation is not matching with one another, my lord. And my lord, mother herself has stated, lordship, kindly below. Mother, my lord. Mother of the informant, lordship, kindly will look page 20. At least basic allegation should be matched, my lord. Page 20, my lord. Mother of the, my lord.
Please read.
The incident took place on 17/7/2023. I was not present at the time of incident. I only came to know that my son-in-law Ashikuddin Loskor was murdered by his brother Mashukuddin. I only heard that Mashuk inflicted some injury with some rod, iron object. Runu Begum, the sister of the Mashukuddin, told that Ashik suffered a stroke and died. Police record my statement.
So
Now, my lord, I heard that Runu Begum told other that Ashik suffered a stroke, my lord. Now, my lord, Ashik suffered a stroke, and this allegation is, my lord, denied by the IO, page 23, my lord. Next page, my lord. PW6, my lord. Rana Begum Loskar did not state before me that Runu Begum told that Ashik suffered a stroke and died. Not a, my lord. He died, my lord. Of course, my lord, there is a dead body. He died, my lord. But how he died, my lord?
I don't know.
Therefore, my lord.
Only you know, but you're not.
Yes, my lord. They have to show that, my lord, this crime was committed by this humble appellant before your lordship. But no, two person is not saying same thing, my lord. All are, my lord, same story is narrating by the different person, my lord. And IO himself, my lord, stated that, my lord, they were secretly burying the dead body, my lord. Is it believable?
Informant explains that part in the informant's examination.
But
Explanation is there.
yes, my lord, but this explanation is, my lord, contradicted by the IO, my lord. IO is stating different story. How he, my lord, put up the, my lord.
There's nothing here. There's nothing here. No weapon seized.
No weapon also seized, my lord.
Naturally, he disappeared straight away. You see, because the witness out here has said, Mashuk didn't call my husband outside of home, first kicked him, and all that is done. But then you completely disappear. Where did you go for? You went for work.
My lord, kindly, my lord, suppose, my lord, one
call for
person,
interview.
suppose one person, my lord, suppose one person, even, my lord, assuming, suppose, my lord, one person, my lord, inflicted, my lord, fatal injury to another person, my lord. Can they, my lord, treat, my lord, my lord, give treatment in their house, my lord.
No,
But here, my lord, it is,
not on that. The first thing is, you were with your brother. Your brother died on that day. But you are missing for 1 year.
no,
more
my
than a
lord,
year.
this is my lord, my lord, in the, my lord, in the, my lord, way of criminal case, my lord.
You were what?
My little understanding is there, my lord. My lord, we are, my lord, beneficiary of doubt, my lord. Doubt, however, may be strong, my lord, that cannot, my lord, take the place of, my lord, substantive evidence.
There are eyewitnesses. What do we doubt? The PW.
Eyewitness, my lord, what eyewitness is saying, my lord? Eyewitness is saying, first, my lord, contradiction. Eyewitness is saying, my lord, he was immediately brought to the hospital. And in the hospital is denying, my lord, we have not seen such kind of incident, my lord. What remains in this case, my lord? Nothing. That apart, my lord, had this incident was taken place, my lord, she is a matured woman having child and already married off, my lord, with the alleged deceased person, my lord.
They had gone to the PhD. But in PW1 does not talk about it. That's what. Huh? I'm just supposed to look at that in detail.
Then, my lord, another aspect is that, my lord, is it believable, my lord, my husband is killed someone, my lord, and I am not going to police station.
Why not?
It is earthly not believable, my lord. What is not earthly believable, or particularly what is not acceptable in the reasonable classes of people, my lord, it is not, my lord, acceptable in the criminal justice system.
What is
Because
not believable?
it is impossible according to my understanding, my lord, if my husband is killed someone, my lord, and someone is preventing to go to the police station and I am prevented, my lord. And next day, my lord, police somoto coming and dead body is taken to the hospital and he is doing all this, my
These
lord.
are
terminated.
hypotheses, not reasonable doubt. You'll have to bring out a reasonable doubt
Yes, my
to
lord.
get the benefit, not some hypothesis.
No, my lord, this is, my lord, on reasonable doubt is that, my lord, when someone is taken to hospital, Lord, and this is her specific statement in the FIR as well as in her evidence, my lord. He was taken to hospital.
What we don't understand is, on the day your brother died, you had gone to some city to start making
Of
chow
course,
mein.
of course, my lord.
To start making chow mein in some restaurant,
No, my lord.
so that you will get
Thing is that, my lord.
one day.
Of course, my lord, there are other brothers is also
To do.
well, definitely, my lord, their relation was not good. Therefore, my lord,
So you disappear.
my lord, otherwise, my lord, in a murder case, why he should be, my lord, entangled or involved, my lord.
Okay.
Definitely, there was a
Okay, we have heard. I think we have heard you. Now, yes.
In FIR itself, Lordship,
Ah,
page number 5, when I took him to Udaban Health Center,
ah.
the aforesaid accused Runu Begum hid the truth and lied to the doctor that it was a case of accident. So then the doctor referred the victim to Silchar Medical. But he was not at all treated, Lordship. Then what the hospital will say that we have treated or not treated? When they are brought. And Lordship, on regarding the part of doing the janaza of the dead body, Lordship, she have already made clear. She was not in a hurry. Her sister-in-law was hurry.
and
Lordship,
sister-in-law is, my lord, already acquitted in the case, my lord.
Doesn't that sister-in-law was not.
medical is totally clear, Lordship. It is from a double form, not from single form.
What happened? What happened was he fell.
So, Lordship.
He fell on the iron rod,
Lordship.
and he came out, and again he fell again. Then now he jumped onto it to make sure that he died.
And Lordship, page number 70, Lordship. Sketch map, Lordship. There is
70.
71.
Yes.
There is no such iron rod wherefrom it can be detected that he fell on the iron rod.
No, D says indicates new perspective. D.
D.
Uh-huh. Unfortunately, you disappeared for
1 year.
year.
This is, my lord, the
1 year,
criminal, my
5
lord,
months.
with my little understanding, my lord, this is.
No, your little understanding thing will not do. You've got to have a lot of understanding. If your brother dies today, you don't go for a foreign trip on the day your brother dies. You usually cancel your foreign trip, and probably you did not go to any foreign trip. You did not even
And but falling down.
go for any interview or something like
This
that.
is, this part is definitely.
You went to do what? To take a long walk, and you walked for 1 year, 5 months, and came back after that long walk.
Generally, my lord, we find, my lord, in the 90% cases,
Ah.
defense do not give any evidence in the criminal case, my lord. Defense evidence, my lord. They are only
Brother
deny.
falls that she, own brother, we carry him to the hospital immediately.
Your sister could have given evidence in your favor.
She was also accused, my lord. She was trying to hide the incident, according to them, my lord. But in this case, my lord, there is a serious, my lord, there may be, my lord, criminal case, my lord, they have to prove the case, my lord, in accordance with law, my lord.
Now,
Here, my lord, as per my understanding, my lord, there is a, my lord, serious glaring, my lord, contradiction is there, my lord. There,
have you seen any person in your have you heard of any person in your life who has fallen on iron rod, 6-7 iron rods, who have got their bodies impaled and who have managed to come out of that?
this is, my lord, they have to, my lord, prove the incident, my lord, in this
Right.
case. My lord, then, my lord, I am not, my lord, the main matter may be hard, my lord.
No, we are disposing the entire matter.
No, my lord, kindly, my lord, I will,
There is nothing.
my lord, kindly with folded hand, my lord, I will submit this in.
Sorry.
My lord.
No. I'm sorry. We have heard it.
Lordship, kindly, my lord, matter may, I have not come at all, my lord, with prepared, my lord, it is a life imprisonment, my lord.
The appellant.
My lord, kindly, my lord, with folded hand, my lord.
Please take
Mr.
your
A.
seat.
Begum, learners, additional PP. Hearing concluded, judgment reserved.
My lord, kindly, my lord, this is, my lord, one life is, my lord, involved, my lord. I have come on only for IA, my lord.
You go to Supreme Court.
My lord, kindly, my lord, one day time may be given, my lord, I will come, my lord.
Lordship, I'll give one judgment. I'll
My lord, kindly, my lord, with folded hand, my lord, this is a matter of, my lord, life imprisonment, my lord.
Correct.
My lord, I am misled, my lord, because IA has come for hearing, my lord. I have not, my lord, had, my lord, in the, my lord.
Sorry. It says IA with criminal.
Yes, my lord.
So we're disposing both. With criminal. It doesn't say-
Kindly, my lord, I may be allowed only one day time, my lord, to hear in the main case, my lord, because it is a life imprisonment, my lord.
We have heard
I,
it. What
my lord,
can you say?
I am admitting, my lord, I am not at all prepared for the final hearing, my lord. I have just for IA. I mentioned also, my lord, made for IA, my lord. This is a life imprisonment, my lord. I cannot, my lord, cheat my client, my lord, in this way, my lord, because.
You are not cheating anyone.
My lord, kindly, my lord, I may be allowed, my lord, for my sake, my lord, only 2 days time, my lord, I.
Argued already, what more to
My lord,
argue?
I have understood, I am for only come for IA, my lord. Kindly, my lord.
We cannot allow.
Kindly, my lord, any date will part that matter, my lord, maybe, my lord. Only one day, my lord, time may be allowed, my lord, I will come, my lord.
You can go to